Vaidehi, we are live now. You can start.
Thanks, Sahil. Welcome all. Namaskar. Pune Collective मध्ये सगळ्यांचं स्वागत. As we all know, the Constitution of India has guaranteed us the freedom of thought, expression, belief, worship, and faith, and has entrusted us with ensuring the above along with a life of equality and dignity. It is a framework that demarcates structures of and procedures for governmental institutions and sets out the fundamental rights, directive principles for the state and duties of the people. Thus, the Constitution and its preamble define the kind of society we as the people of India want to live in. गेल्या काही काळात या सर्वांवर प्रत्यक्ष आणि अप्रत्यक्ष असे हल्ले होताना दिसतात. पण असं जरी असलं तरी या हल्ल्याच्या विरोधात अनेक आवाज उठताना देखील दिसतात आणि ते आपण पाहतो. यामध्ये महिला आहेत, विद्यार्थी, श्रमिक, दलित, शेतकरी तसेच कामगार वर्ग आघाडीवर आहेत. संविधानानं दिलेल्या हक्कांची मागणी आणि त्याच वेळी संविधानाचे रक्षण असे दुहेरी काम आज भारताचे नागरिक आपल्याला असे करताना दिसतात. On this background, Consent City in Pune.
This is Marathi, is it?
Yes, sir. Yeah.
Okay. I can't follow. Anyway, it's all right. Go ahead.
On this background, concerned citizens in Pune have come together to form the Pune Collective, aiming to bring democratic and peaceful voices together. Sir, as we are located in Maharashtra, so we thought let's have some conversation in Marathi too. So that
but unfortunately, I'll not be able to participate in that part of the conversation. You'll forgive me for that. It's my limitation.
No issue. Only 2-3 lines.
Yeah. No, I can't. I really wish I could, but then I can't.
So,
if somebody can translate it to me in between, if whenever some question is asked or something, one of you need to translate.
Yes, sir. I'll do it in Hindi and English both.
No, Hindi also I can't speak. Okay, I broadly understand Hindi. I can't speak because the grammar I'm not trained. But I broadly understand Hindi conversation. Don't speak that high-flown Hindi. I can't understand. But normal cinema Hindi I understand. But I am a little hesitant to speak. I watch Hindi movies.
Just 2-3 more lines.
Mainly it is going. Mainly it is going to be in English with you, sir. Yeah. And some part of it would be in Marathi because there is a Marathi audience.
No, not at all. Most welcome. I am not objecting to it. I can't object. I'm putting forward my inadequacy.
Of course. Yes. Yeah. Okay. Yeah.
पुणे कलेक्टिव्हच्या या माध्यमातून आम्ही समकालीन राजकीय तसेच सामाजिक भवतालाशी जोडून घेत संविधानाला अपेक्षित मूल्यांची उजळणी करू इच्छितो. याचाच एक भाग म्हणून आम्ही आज हम अगर उठे नहीं तो या देशव्यापी हाकेला साथ देत आहोत. लोकतंत्र, संविधान, प्रदत्त अधिकार, न्यायपालिका की स्वतंत्रता और अन्य संस्थानों की निष्पक्ष कार्य प्रणाली पर संकट के खिलाफ महिला, मानवाधिकार और LGBT संगठनों की ओर से आज जो देशव्यापी अभियान शुरू हुआ है उसे हम पुणे कलेक्टिव की ओर से सलाम करते हैं और हमारे आज के कार्यक्रम के द्वारा इस आवाज को बुलंद करते हैं. So friends, let us start with our today's session. So today's topic for discussion on this 4th session of Pune Collective is Judicial Duties and Democratic Rights. म्हणजेच न्यायालयीन कर्तव्ये आणि लोकशाही अधिकार. Judiciary is one of the cornerstones of our democracy. The constitutional courts are said to be the guardians of our fundamental rights and are expected to put checks on the state. While the judiciary, in principle, is supposed to be independent and thereby unbiased from the other governing structures, it has been subject to considerable criticism in the last few years. We feel it is important to discuss the Indian judicial system, its accountability, and its implications on the democracy in our country. In this 4th session of Pune Collective, we'll be joined by 2 towering personalities. Former Supreme Court Judge Jasti Chelameswar, and a social activist and assistant professor at ILS Law College, Dr. Nitish Nawasagaray, sir. I welcome you both, sir. A brief introduction about both the speakers. Justice J. Chelameswar is a retired judge of the Supreme Court of India who served in Supreme Court for 7 years from 2011 to 2018. He has also served as Chief Justice of High Courts of Kerala and Guwahati. Justice Chelameswar has given notable judgments related to freedom of speech, such as striking down of Section 66A of IT Act 2000. He was also one among the 4 judges of the Supreme Court who held the press conference in 2018, raising issues affecting the court. They pointed out that unless the institution is preserved, democracy will not survive in India. We welcome you, sir.
Thank you.
Let me welcome our second guest, Dr. Nitish Nawasagaray, sir. He is an assistant professor at ILS Law College, Pune. He has teaching experience of nearly 2 decades, a published author, and has extensively written in newspapers and magazines. A civil rights activist, founder member Dalit Adivasi Adhikar Andolan, and organized an organization working on the civil, political, and economic rights of Dalits and Adivasis. He has actively participated in movements of unorganized workers, especially of the landless Dalits and Adivasis. He is actively involved in providing legal assistance to the victims of caste violence in and outside the court. Welcome to Pune Collective, sir. So I'll just brief out overall session structure here. It will be an interactive session. We'll also take some questions from audience at the end. You can type your questions in the comment box or chat window. We'll share it with the speakers. I request participants to keep their microphones off, and so that we'll not disturb the speakers and other participants too. Now, I would like to request Dr. Nitish Nawasagaray, sir, to take the dais. Over to you, sir.
Thank you so much, Vaidehi. Honorable Justice Chelameswar and organizers of Pune Collective. Thank you so much for calling us here. And we would start with the discussion. And the way it has been organized, it was informed to us that I will give some introductory remarks. And with that, the main talk of His Lordship Justice Chelameswar will follow. Then after we have some questions framed, we'll have a question answer session with His Lordship. And thereafter, we'll open the forum for discussion for others. To start with, let us start with where the story begins. And Dr. Ambedkar, when he spoke about Indian democracy, he categorically said that in India, democracy is a top dressing on an inherently undemocratic society. And therefore, I suppose when on 70 years back, when we declared India to be sovereign, republic, democratic, he was very clear that it's merely a political democracy that we are introducing right now. And social and economic democracy is the target to be achieved by this political structure. And therefore, whole of the constitution was designed in such a manner that we would have a social and economic democracy established. The role played by the parliament, the role played by the executives, and the role played by the judiciary is remarkable in the last 70 years. Coming to a part of Indian judiciary, we had what Glanville Austin spoke about, that we had various phases of Indian judiciary coming up. So initially a very conservative judiciary, which was taking up to a black letter interpretation. And they would say that if it is not written in the constitution, we will not uphold it. So directive principles of state policy will not be upheld vis-a-vis fundamental rights. And at the same point of time, we have a parliament which was bent upon to bring land law reforms, zamindari reforms, and it was bent upon to bring up social justice and economic justice in the political sphere. This judiciary changed with the decades of 70s, when people who are having a background of socialist orientation came into judiciary, and they started giving judgments which were pro-people. And this was a time when we started coming up to or looking at judiciary, that judiciary is the conscious keeper of your constitution. The judiciary is the custodian of your constitution. At the same point of time, we said that judiciary is basically considered to be putting up a clear watch on the functioning of the executives and the parliamentarians. The people of India started exhibiting a lot of faith in the judicial structure. We started getting compensation from for this constitutional wrong conducted by the executives. We started striking down the legislations which were against fundamental rights of the person. We started reading directive principles in the fundamental rights, and judges and judiciary became the real heroes of Indian people. It was the last recourse where we could go and speak for enforcing our constitutional rights. But then came an era wherein at some point of time when Professor Sati has categorically said that Indian judiciary has very well performed apart from few patches of emergency. That was a time when the executives were looking for and asking for a committed judiciary. And here the question comes is, what is the character of a judiciary? We spoke much about parliament, we spoke much about the executives, but it was always considered to be blasphemous to speak about judiciary. But then this all broke down when 2 years back, the judges itself came out and said that everything is not going right. There is something going wrong and we owe a duty to our nation. We should speak to our nation that something is going wrong. It was not the first time it should have happened. It was the first time that it was happened that judges came out and they spoke. But it was not the first time when the judicial character was questioned. It was questioned in courts. It was questioned in parliament. It was questioned in public forum also. It was questioned that how do you appoint your own judges? It was questioned that how itself that you people from the same bar, people from the same class, and people from the same caste get elevated. It was questioned that you have a class bias, and then it was considered to be a contempt petition. Shiv Shankar's case we are talking about. And therefore, this question came up, that what is your class structure? What is the diversity index of judiciary? And these questions they came up, it was never discussed in public at all. Recently, with what happened with Prashant Bhushan and the contempt issue started coming up, let us, if we don't even go to the facts of the case, something which becomes very important, that should we not question the character of the judiciary. And if that is the case, we are talking about, should we say that the judiciary should have certain democratic qualities? Is it something above this part that they will not be answerable to anyone? To answer this question, that whether judiciary should have certain democratic qualities, are they answerable? Are they accountable? And his lordship has said that independence and accountability comes together. You can't have independence without an accountability. So how far the judiciary is accountable and to whom they are accountable? I think these are a few questions which we propose to discuss today. We propose to deliberate today. And we are very clear about one point, that it is only through discussion, deliberation, and freedom of speech and expression that ideas will conflict with each other and truth will come out. So it is the quest of truth which makes us to question that whether judiciary is accountable and to whom. Therefore, judicial duties and democratic right. This is the topic which we have for discussion. May I request His Lordship Jasti Chelameswar to keep his view on this topic, and then after we'll open the forum for discussion. Thank you so much.
Thank you, Nitish. Now, let me examine a couple of areas before we talk about the judiciary and its accountability, whether it's accountable at all, if so, to whom, and all these questions will come to a little later. As you pointed out in the beginning, Baba Sahib's statement that it's top dressing, it's only political democracy, a social and economic democracy is it to be achieved. Now, after 74 years, we need to examine, did we really achieve even a political democracy? In the sense I'm serious. What do you mean by this political democracy? A very basic understanding is, instead of some hereditary rule, the lawmakers and the executors of the law, the administrators of the law, are chosen by a periodic election. If that's what we understand basically by democracy, then do we believe that it is a political democracy we have achieved? Now, is it only requirement is that a periodic election and nothing more? What mode of an election and what quality of elections are taking place in this country, I suppose, are relevant questions. I don't know about Maharashtra. I can have a vague guess. It's too well known. I have heard quite a few elected representatives making statements on the TVs regarding the phenomenal amounts they had to spend to get elected to a legislative body, either assembly or parliament. And a few years back in Delhi, 3 years while I was still on the court, on one of those occasions when in a gathering like this, the former election commissioner, one Mr. Brahma, he was the election commissioner of India at some point of time in India. Am I audible clearly? Hello, hello, hello.
Yes, sir.
Am I audible?
Yeah,
audible?
yeah. Yes,
oh,
yes.
Okay. Mr. Brahma made a statement in this gathering, a small gathering of about 100 people, and most of them were people, either men or women, who held some responsible constitutional position at some point of time or the other in this country, including on that date. Some of them are holding offices on that date of the meeting. Mr. Brahma, who by then he laid down the office as Chief Election Commissioner, made a statement that people spend about 50 crores to become members of the parliament. The response of the gathering was smiles. Now, if a former Chief Commissioner is saying that people spend about 50 crores for becoming members of the parliament, it's a matter of serious concern. But unfortunately, we have reached a stage in this country that our reaction is only smiling, nothing more than that. We are not able to handle the situation. So, therefore, what kind of a political democracy is this? No, I know no democracy is perfect, and then democracies are always continuing experiments. Things are always, in every democracy, these problems were there. Well, over a period of time, then societies mature democratically and control some of these things. That's a different matter. Similarly, when you talk about democracy, it's not only voting and periodic elections and voting, and also certain other things. An executive which is accountable primarily to the legislature. And in the last 75 years in the party system in this country, and more particularly political parties have become in the last 70 years essentially the fiefdoms of individuals who are irrespective. But I don't think there is any qualitative difference in all these political parties. It's just one man or one woman or a small group of people who control the parties. This theoretical accountability of the executive to the legislature is almost become a rhetoric, because those who get elected to the legislative bodies, or those who desire to get elected to the legislative bodies, necessarily have to demonstrate their loyalty to the leaders who get them. Because we have seen most of the time it is one man who gets, or one woman, I'm sorry, to make all these people get elected. Remove that person, one personality, man or woman, quite a large number of these people, good number of these people would simply not win the election. It is that umbrella which gives them an opportunity. Therefore, they are bound to be loyal to that leader. Now, after that, the principle that the executive is answerable to the legislature becomes only a theoretical statement, but in fact, we know what happens in this process. Now, the other aspect of the political democracy is the system which we have chosen, that the activity of the legislature and the executive are liable to be examined by judiciary in the context of the question whether those activities are consistent with the fundamental law of the country, that is the Constitution of India. And now it's there, this proposition of the existence of an independent judiciary comes into play. Well, as Nawasagaray was mentioning, the role of the judiciary in the last 75 years, there are various shades of the performance of this obligation, constitutional obligation, of adjudicating the consistency of the legislative or executive action with the Constitution. We have known. Well, libraries can be written both in favor of the performance of the judiciary, or maybe sometimes against the performance of the judiciary. This is true of any nation. We take the American Supreme Court, for example. Well, it has its own problems, ups and downs, and consistency of its commitment to the core constitutional principles. Well, there have always been comments. The point is, it is in this background we need to examine the accountability of the judiciary in this country. Now, all constitutional governance systems are based on a fundamental belief that these bodies and the people who man or woman these bodies are only there to serve the people of the society which chooses them, the country. Don't call it a country or a society, whatever, maybe a body politic. They are meant to serve those people in different capacities. And in the process of that service, each one of these bodies is entrusted with certain duties, obligations. And the performance of those duties or obligations, they are also invested with certain powers. Because without those powers, the performance of those duties and obligations could become impossible. But they are interested. But whatever be the nature of the powers or obligations of each one of these branches of the governance, the basic principle in a democratic society, as I understand, as I'm sure all of you would agree, is that all this is meant for the benefit of the people, welfare of the society, the body politic. And necessarily, sorry.
So just a quick request, people are not able to hear you properly, so can you please
Okay. Now.
Sorry to interrupt.
No, it's all right. You want me to repeat the statement or what?
Yes, sir.
See, in this process, each one of the organs of the state functioning under the constitutional system is required to be working for the welfare of the people. Independent of the welfare of the people, these bodies do not have any, there is no need for the existence of these bodies under the constitutional system. Now, if it is meant for the welfare of the people, one basic requirement is whether a body is functioning properly or not in the interest of the welfare of the people of this country. There must be some amount of accountability. There must be accountability. Now, in what form the accountability is required to be there? What are the modes of Ensuring the accountability may vary with the nature of the organ, is the legislature or executive or the judiciary. But accountability is an unquestionable principle. Now, one more principle is, the minute you talk about accountability, transparency in the performance of its duties or obligations or responsibilities is essential for people to make an assessment whether these duties and responsibilities are being performed in the interests of the people or not. That is one major aspect of the accountability process. Now, when you talk about the accountability of the legislature, the principle is simple. A periodic election is a basic requirement of the accountability of the legislature. If people believe that the members of the legislature, be it the state legislature or the parliament, are not functioning in accordance with the constitutional requirements as the people understand, not that their understanding is conclusive, but by and large, the understanding of the people, ultimately they know what is best for them, though there are limitations to that understanding sometimes. So that the periodic audit of their performance is there, and the accountability is the main aspect of the accountability of the elected bodies and members of the elected bodies comes through the process of a periodic election. Apart from that, there are certain fundamental constitutional norms laid down in the text of the Constitution and in the constitutional conventions. It's not only that they should go through a periodic election, there are certain they are required to function in accordance with certain proclaimed procedures and principles in the Constitution. Merely because they're elected there and they have a majority, they can't do whatever they like. Let us say they can't make laws in violation of the fundamental rights or various other parts of in violation of the distribution of powers. Let us say the parliament can't make a law pertaining to a subject matter which is exclusively assigned to the legislatures of the states. Like these are the limitations and accountability processes of the legislative elected bodies. Coming to the executive bodies, the accountability is twofold. One is for what is ultimately what. Now, there are great myths which exist in all the minds of the mankind. We believe the presidents, the prime ministers, the governors, the members of the cabinet, the judges, so on and so forth, holding high offices, are great people. No, individually, some of them may be really great people with great personality, great sacrifice. So I'm not saying. But the point is, when the ultimate responsibility of the executive, legally speaking, what is it that the executive is supposed to do? The basic responsibility of the executive is to faithfully implement the provisions of the Constitution and the law enacted by the elected representatives of the people. The basic obligation of the members of the executive government, either the political executive or the bureaucracy, is to enforce the law faithfully, sticking to the letter of the law and the principles of the Constitution. Now, whether a particular decision taken by the executive is strictly consonant with the provisions of the relevant provisions of the Constitution and also the relevant provisions of the law which they are seeking to enforce. There can always be questions and doubts about the correctness of the way in which the law is being implemented. So somebody needs to examine it. So who is that somebody who is authorized by the system to examine the correctness of it? It is a judiciary which is authorized by the Constitution to examine that. Therefore, if the judiciary is required to examine the correctness of the action of the executive, or for that matter, the correctness of the law made on the touchstone of the Constitution and the principles laid down in the Constitution. Obviously, the judiciary is expected to be an independent body, a judiciary which is willing to oblige either the legislature or the executive for the time being, can't be an independent judiciary. It has to make an independent assessment. Now, for making such an independent assessment, the judiciary is required to have a certain degree of competence, certain degree of training, certain degree of commitment to the constitutional goals and principles. There are different requirements for being members of the judiciary. That's a different topic altogether. But that's the responsibility of the judiciary. That's the requirement of the judiciary. And how do we ensure that independence is one question which troubled the mankind for centuries, not today. So by experience, mankind identified the areas which can compel the members of the judiciary to compromise on their independence. Now, what are these various components which can provide an occasion for the members of the judiciary to compromise? One is the appointment process itself is an aspect by what process the members of the judiciary are chosen. The quality of the minds, their efficiency, their commitment to the values of the Constitution, their neutrality to the electoral political system. Indeed, they may have theoretical preferences in the political philosophy, but in the context of electoral process, they are required to be independent of likes and dislikes in that matter. When it comes to the question of performing their judicial functions. So that's one thing. So therefore, what is the process by which the members of the judiciary are chosen? And how are they required to be insulated from the interference of the executive or the legislature once they're appointed to be members of the judiciary is the second question. Now, the easiest way to destabilize any human being is hit at the belly. So, in fact, examples are not lacking in human history. In our own country, let us take the very earliest during the East India Company days, Sir Elijah Impey, the Chief Justice of the Supreme Court at Calcutta. And the Supreme Court decided something which was not palatable to the Board of Directors of the East India Company. The board passed a resolution to stop the payment of salaries to the judges of the Supreme Court of Calcutta. So that's the easiest way to arm twist any human being. If you starve a man or a woman for a couple of days, quite often, barring very few bold and highly determined souls, quite a large number of human beings succumb to that pressure. Hunger is something which all of us are this thing. So one way of doing it. So therefore, there is a constitutional provision saying that the salaries of at least the constitutional courts, Supreme Court and High Courts, are not made subject to any voting. They are charged on the consolidated fund. That's one way the Constitution thought, this process of manipulation is not permissible. Similarly, the other thing is removing from the service. Okay, if you don't listen to me, you decide something against me, I'll throw you out of the service. It's public. Even in the context of an ordinary member of the bureaucracy, the Indian Constitution says there are certain stipulations you can't simply throw away. In US, it is simply possible to hire and fire a member to the service of the government. In India, it is not possible. If some of you, I'm sure some of you are lawyers and teachers of law or students of law, you know there are specific provisions under the Indian Constitution as to how a person recruited to the service of either the government of India or the government of the state. If the person is to be removed from service or dismissed from service or some disciplinary actions to be taken, certain fixed norms are there prescribed in the Constitution. Only in accordance with the norms those persons in service could be dealt. When it came to the judiciary, which is required to have a much higher degree of independence, removal from service is made the most cumbersome. It's only by a process of impeachment. Impeachment also a cumbersome process of impeachment with specified majorities and not only a simple majority question, impeachment on grounds mentioned in the constitution, not on the ground because the parliament doesn't like the face of this man or the language of this man. That the sorry, forgive me, ladies, when I say a man by sheer habit. In law, man always includes a woman. No, if a judge, let us say the more neutral term, the only way to impeach a judge is to first establish that the judge has misconducted in the duties, in the performance of his duties, or something connected with the performance of the duties. Not that he went and had a drink in a club or something like that. That's not the point. Misconducted. And upon that, by a special majority, the parliament, only the parliament, state legislatures do not have the authority to deal with the judges of constitutional courts, high courts or Supreme Court. The majority of the parliament, special majority of the parliament determines to impeach the person, only then it's possible. So it's a great safeguard so that judges do not have to worry sitting there, look here, if I take this decision, the government or the parliament may be unhappy with me, the state legislature may be unhappy with me, they may throw. This, they are relieved of that problem. And it's very difficult in this country to really impeach a judge. That's a different story. All these protections are given to the members of the judiciary for the purpose of ensuring their absolute independence from the legislative bodies and the members of the executive. When and coupled with all these protections, a further provision is made in all the societies, the authority to punish somebody for contempt of court. And then there is a problem. Contempt of court is of two varieties. Civil contempt. Court decides something, gives a decree in favor of X or Y, and the judgment debtor does not permit the decree to be executed by some way or the other, stopping it by illegal means. Stopping it means if it goes to a higher court 6 days, that's a permissible mode of stopping it. But then when there is a final decree, there is no further appeal or revision, anything, the decree has become final in all respect. Still the man or woman, the judgment debtor, comes in the way of the implementation, then it is defiance of the orders of the court, that is civil contempt, for which obviously there can't be any objection, because otherwise the system would fail. The court gives a grand declaration and a decree which can't be implemented, then there's no use of such an institution. No. The other thing is this criminal contempt. This, of course, it exists in some jurisdictions. In Britain, it existed for a long time, just about maybe the exact year I don't remember. Britain, by a law, abolished the criminal contempt. And in America, one hardly ever hears about somebody being punished for criminal contempt, because the American society values the freedom of speech so much. Freedom of speech at the top, rest of the constitution later. Now, India, unfortunately, we still have on the statute book, the Contempt of Courts Act has a provision dealing with the criminal contempt and the punishment for criminal contempt. And there the question of these accountability questions come. If somebody, then of course periodically these questions arise. Is criticizing the judiciary permissible? To what extent it's permissible? What are the areas in which the judiciary could be criticized? By and large, it is agreed even today that criticism, academic criticism of a judgment already rendered by the court, can be academically criticized subject to the norms of decency. You can't use foul language and things like that. I'm not on that. But you can always say, look here, this judgment is flawed for X, Y, Z reasons. You give the reasons. Your reasons might themselves be right or wrong. When examined independently, somebody may say to you, look here, your logic is wrong. That's a difference. But so long as it's an honest exercise, in academic exercise, examining the correctness of the judgment, that is even today it is not considered to be contempt in this country. Well, there are some areas where certain conduct by the people regarding the activity of the judiciary, which attracts this debate, whether it's criminal contempt, whether it should continue to be there on the statute book or not. Well, there are opinions and opinions. Let us say, as of today, the fact remains it exists and it is there. And we have seen the exercise of that power very recently. Whether it should be there, continue to be there or not, is a matter of opinion. It's for the body politic to decide and raise questions about it. But point is, one question which always was raised, see, making an allegation of the existence of corruption in the judiciary, for example. To what extent it can be made, to where that such a statement could be made, so on and so forth, are questions which trouble the Indian system, Indian society, repeatedly. Now, the case law, of course, you can study, but I am on a more fundamental thing. To believe that corruption does not exist in this branch of the constitutional governance would be deception in my belief. Because we know the society. After all, like, see, it is possible in this country, whether true or false, justifiable or unjustifiable, to say the Prime Minister, whoever it is, I'm not talking about present, past, future, I'm not talking about. It's possible to accuse the Prime Minister. We know in this country, late Mr. Rajiv Gandhi was accused of corruption in the Bofors case. Anyway, what happened to that thereafter, all of us know that's not the point. The point, it is possible. You can call the Prime Minister corrupt, you can call a Chief Minister corrupt. A couple of them went to jail also on that charge. But then this branch of thing is to say that this branch is absolutely immune. Nobody can ever say it under whatever circumstances is a principle with which I can never agree. That's as a proposition, as a logical proposition. An individual case, whether an allegation is true or false, if it is true, first of all, where to make that allegation, how to make that allegation, there are different considerations. We are on a larger question whether it is possible or not. And I believe it is possible to make a statement. In fact, I have to answer a question in the context, though you are not asking right now, but here and there questions are asked to me. In that unfortunate case of Justice Karnan, to which to that judgment, I was a signatory where Mr. Karnan was found guilty of contempt. But the sad thing is, quite a large number of people who criticized me for the judgment perhaps haven't read my judgment completely. The case against Mr. Karnan was that he made various statements. Actually, you can see it from the majority judgment of Chief Justice K.R. He has given a large list of incidents in which Mr. Karnan has made various allegations against various judges. It was the basis on which the contempt case was taken up and things went on. If you kindly read my judgment, I never held him guilty for making those statements. I said if only this man entered defense and argued, he might have been able to prove his allegations, might not have been able to prove his allegations. I don't know what material he has in his possession when he made that allegation. If only that man entered his defense and produced the material, or even if he doesn't produce the complete material and entered the defense saying that then I believe for XYZ reasons that these people, and then whom did they address those communications? The President of India, the Prime Minister, the Chief Justice. Well, if I believe that X is corrupt, where do I go? If I can't tell the President and Prime Minister or the Chief Justice of India, whom else will I tell? So the forum is also equally important. Now, the point is not that. What I said is his post-notice conduct, The man didn't allow the proceedings to go on. He kept on passing orders saying that you shall not hear. I am passing a judicial order prohibiting you from deciding my case. This is interference with the judicial process. When the highest court of the country is hearing a matter, you may reach whatever right conclusion, wrong conclusion, that's a different story. But you, as a member of a high court, against whose orders an appeal can go to the Supreme Court, start passing orders purportedly in exercise of judicial powers to say, stop, don't pass these orders. I'll haul you for contempt. This kind of orders were passed by the gentleman. I and Justice Ranjan Gogoi, who signed with me in that judgment, we held this part of the conduct certainly constitutes interference with the judicial process. We never held that man making a complaint against XY judges because we didn't decide, because there was no occasion. That man didn't enter defense. He said, I'm not entering defense. In fact, in the courtroom drama, he said, no, send me to the jail straight away from here, he said. In fact, I personally requested him, Mr. Karnan, please make your submissions on merits. We would like to hear you. The man refused to make a submission. We were helpless. If only that man entered his defense, this great question, to what extent such a statement could be made, to whom it could be made, to what extent a citizen so freedom is available, to what extent his limitations are there. These are all questions which, in fact, I said so in that judgment. But to believe that nobody can ever make that statement to anybody is something which I am not willing to agree with. So, when we're talking about the accountability is a must, otherwise it ceases to be democracy. And if the parliament is accountable periodically for its performance, and if the executive is accountable always, both to the parliament, at least in theory, whether it's happening or not is a different matter, it's answerable to the parliament and also to the judiciary by way of a judicial review, to say that this one organ of the constitutional governance is not accountable at all to anybody, well, doesn't hold any logic. At least I find it impossible to agree with that kind of situation. I don't think anybody, even somebody who is accepting the greatest power of contempt, I don't think any judge would even subscribe, at least in theory, to that statement, that we are not absolutely unaccountable. Well, then of course, you know what all is happening. I think at this stage, I'd like to stop my statement. Maybe we can discuss further with the balance of the time. What do you think, Professor Nitish?
Yeah.
Should be all right?
Thank you for making your opening remarks and making it categorically clear that accountability is must. Also making it very clear that if you believe that corruption does not exist in this branch of the state, then it would be a very illogical proposition. And I suppose, sir, this speaks loud, this speaks volumes.
One second. Just one second. Yeah. Let me not be rhetorical about it.
No, it's, I mean, we don't want to be.
No, 1 second. I'll give 2 examples. See, you remember there is a former judge, Kudusi. He was arrested by CBI, nothing to do with the Supreme Court or anywhere. Yeah. The CBI booked a case against the man saying that this man is trying to pollute the streams of the current, so on and so forth. He was arrested. He was a former acting chief justice of a particular high court in this country. And one thing, if you recollect, another judge whose name was proposed to the Supreme Court and a lot of hell broke loose a few years back. Karnataka. And after that, how can you say that it doesn't exist at all?
Yeah, the impeachment proceeding which were lapsed, basically it itself speaks about the whole thing.
And it happened earlier also in 1 or 2 other cases. Right. And so therefore, to say no, I don't think anybody is willing to make the statement. Any member, of course, they may have different takes on as to what extent somebody can go, who can say it, and when can he say it, to whom he or she can make it. There may be differences of opinion in that.
So let's start with the contempt thing, which was the latest in a discussion. And you made a remark of United Kingdom where now criminal contempt is no more existing. And if I quote Lord Denning in a judgment of 1968, he says that, "Let me say at once that we will never use this jurisdiction as a means to uphold our own dignity, nor will we use this to suppress those who speak against us. We do not fear criticism, nor do we resent it, for there is something far more important at stake, that is no less than freedom of speech and expression. To start with Lord Denning, and we all adore him a lot, sir, the recent incidents which happened in the Supreme Court.
From Denning, but England has passed on. The law itself is repealed.
The law is
on
repealed.
the day when Denning made that statement, the law was still on the statute book. Today, it doesn't exist at all.
That is what I'm saying. But the judiciary has the magnanimity to say that we will never use it, even if the law is there. And now, even if the Contempt of Court Act is repealed, sir, we do have that Supreme Court being a court of record, it can still punish. So that is, let us not go into that. My question coming up to this part, sir, as citizens, we are really not clear about that. When should criticism, a comment that when should criticism, which is an essential element of freedom of speech and expression, does it transgress to contempt of court? What would be this part? Means fair criticism, what we amount to? Because judges taking matters when petitions are filed to be suo motu. And why suo motu? Because the Attorney General has not given any consent. So what do you speak about this big egos of the judges? We're taking criticism.
Forget about egos part of it. I don't want to comment about it. Everybody has an ego so long as we are human beings. The question is, sitting in a public office, how do we regulate our egos is the question. Ego is a part of human nature. The entire Indian philosophy revolves around that one single statement, ego. I am. Forget about it. But then that is required to be disciplined when you are holding a public office, particularly in a constitution. Any government, more so in a constitutional government. Actually, just yesterday there was a similar program. I was not a participant, I was only following it. 3 of the former judges of the Supreme Court, Justice B. Sudarshan Reddy, Justice Kurian Joseph, and Justice Gopal Gowda, and some other, I think some ILU, I think, organized some program about this thing. In fact, this question said the Attorney General is equally a constitutional authority as much as the Supreme Court. And if the law says that the permission of the Attorney General is required, just simply after the Attorney General rejects this thing, we say we still take it up suo motu is a highly questionable exercise. That is the view expressed. More important, preventing the Attorney General to make a statement when he's present. You put him on notice, he comes to the court, but you tell him that we will not hear you on merits. This is his 3 honorable former judges say, we don't understand this process. I can't add anything more to it. I agree with you.
Yeah.
Just yesterday, just around this time yesterday, this program was going on. Maybe it's available online. You can check out.
Yeah.
So in fact, it was a very, very scintillating discussion that went on yesterday.
Right. We don't have any parameter that when a fair criticism transgressed the border of contempt, and it all depends upon the bench and the court how they look at it and how they take it. And that itself, again, the question.
Put it on the lighter wind, it's the spin of the coin which determines.
True. Yeah. So let's come to the next question. And I think this is regarding the press conference. So,
well, I think that's one area where I think I've spoken too much about it. Anyway, it's all right.
No, but the question is not regarding the allegation. The question is regarding something. So some matters are pending in court for years together, and habeas corpus petition has not been heard for years together. And some journalist goes to the court at midnight, at evening, at 8:30 and morning. He has been before the court getting a order from the court. And then the same question thinks that, do you think that there has been a change in allotment of roster post the dissent, what you came through? But you said that there's something rotten. So what is your opinion?
I didn't use the word rotten, but things are not.
Hey, you didn't use the word, but this is what I'm putting into.
Don't, because I'm already in sufficient trouble. Don't attribute things.
No, I'm so sorry. So I didn't want to. So, but so the whole part is about there's an allegation made in the court itself that certain political matters are given to certain judges.
Point is actually forget about these individual cases and allegations. I'll tell you the problem is much larger. At least in the context of the Supreme Court. See, unfortunately, in the history of this country over a period of 74 years, The Supreme Court's jurisdiction and its willingness to examine various matters went far beyond its ability to manage it. Now, as Professor, you know, it's essentially a constitutional court. The primary function of the court is to lay down the principles of constitutional law, how to interpret the Constitution. The appellate jurisdictions, civil and criminal, are very limited. In fact, if you check out,
True, sir.
I'm sure you know as a teacher of law and
Yeah.
those who are not directly connected with law. Even in the case of a capital punishment, there is no right of appeal to the Supreme Court. Only
Statutory appeal.
on a statutory appeal.
Yeah.
That's also 57 Enlargement of Criminal Jurisdiction Act. Only in a case where the High Court reverses an acquittal and awards capital punishment, there is, as a right, somebody can go to the Supreme Court. Similarly, in civil matters, unless the High Court certifies that it's a fit case with substantial, that requirement.
True.
Now, check up in the last 25 years, in how many cases the High Courts granted leave in civil matters for parties to approach the Supreme Court. They simply invoke, nobody's asking, simply go to the Supreme Court, file a petition under 136. And for whatever reason, the Supreme Court was willing to examine those matters. And in the process, there is a huge accumulation of arrears. I always wondered, in fact, I made this statement sitting on the bench on more than one occasion. See, in matters, disputes arising purely out of some local law, unless there is a earth-shaking constitutional issue involved. Say, for example, I'll give you a concrete example. You people are not, all of you are Pune Collective, Maharashtra. Maharashtra, I'm sure there must be a Cooperative Societies Act. There must be a cooperative service in Maharashtra. In some of the states, the service of the cooperatives is integrated. So the entire state cooperative employees constitute one card. Some states, at least, not all the states. Some states there. Now, let us say in a particular cooperative society, let us say Apex Cooperative Bank in Maharashtra, there is a dispute regarding the seniority of the two individuals. And the matter goes up to the High Court determines. And then the unsuccessful party always would like to have another go at it. He comes to the Supreme Court. I believe, why should the Supreme Court spend its time assuming for the sake of argument the High Court's judgment? I don't approve. There's no guarantee my views are right, but anyway, in the system, since sitting in the Supreme Court, my views are supposed to be final, if not infallible. Even then, my belief is, how does it matter to the rest of the country? The Bombay High Court is as much a constitutional court as the Supreme Court. And insofar as matters arising out of the local laws are concerned, which have no bearing on the rest of the country, why can't you just leave it there? Why do you want to undertake an exam? Unless it raises a far-reaching constitutional question. A mere question of Article 14. Well, Article 14 is like the Jundu bomb. It can be applied to any situation.
Everyone.
I'm talking about much more serious questions. Now, if you start examining these things, obviously, you'll not be able to handle the work. And periodically, the strength keeps on increasing. That didn't solve any problem. Only the strength of the Supreme Court kept on increasing, but the arrears never came down. Coupled with this, the court sits in division benches 2, 3, and so on and so forth. And this principle of the master of the roster, well, nobody disputed. Master of the in a court which sits in division benches, that principle has some significance in the sense work is to be distributed. Otherwise, there will be a scramble for the work. I start pulling out whatever I want. But the court which sits in bank like American Supreme Court, this principle has no meaning, master of the roster, because every case is bound to be heard by the full court. So there is no master of the roster, no distribution of work, so on. All right, so long as we continue this system, well, that master of the roster business is there, but then even then it is required to be a structured power. It can't be simply monarchical authority. I decide whatever I like and nobody should question that. Of course, I fail to understand it. But point is, even considering that, we don't follow any system here. Suppose if there were to be a rule, matters would be heard for final hearing in accordance with its seniority. Oldest case first. then this problem doesn't come in whether the High Court is deciding habeas corpus, Supreme Court or High Court is deciding the habeas corpus case first or not. And we follow a system. Sorry, this is the rule. Earliest case, but it may be death penalty, it may be habeas corpus, it may be whatever it is, whatever is the case. You'll have to wait for your turn. That's one way. Then nobody can raise any complaint, nobody can have an objection because we are following some principle. The minute you start picking and choosing, depending upon the personal discretion of either the master of the roster or somebody else, and all these questions are bound to arise. Now, I think there is required to be some arrangement in this. There must be a consensus on this, either by law or by consensus. Determine how is the work to be done. Now, otherwise, these controversies keep arising, and then don't blame anybody thereafter. This is what happens.
Right. Even I suppose the master of roster issue is still very much there in the Supreme Court, and what you are seeking, what you have been recommending is that there should be a well-settled law regarding how the matters would be distributed amongst the judges and amongst the benches, so that it would bring an transparency, and what we spoke about transparency and accountability both do matters a lot, and that would also change the public perception, because this all means common person sitting in Pune would always say that how this could happen, and therefore we have thought. Means this is one question which we have received, sir, that the public perception of the functioning of the Supreme Court is in last 6 years is that the priorities of the court in function has been completely different. Means it happened with the abrogation of 370 and people rushed to the Supreme Court to look into the matter, or habeas corpus issues where the people came, or after COVID-19 lockdown, people thought that Supreme Court should have intervened, where Supreme Court never intervened. And then there are a few other matters where priorities were given, which were not much of national interest. And therefore, this whole idea that the recent few incidences, we don't say that this is all about Supreme Court is about, because we have a Supreme Court which gave Puttaswamy judgment making privacy to be a fundamental right. And therefore, it's not the whole plot on this, but something that in recent time, it is always thought that public perception has hampered. And also because post judgments appointments, which has come up for discussion in a recent thing. So if you could comment on this issue, sir. Let me put it just 1 second that Mr. Arun Jaitley, when he was the leader of opposition in Rajya Sabha, he made a statement saying that
yes, I know that.
Just for the audience, for this purpose, that there should be no post-retirement appointments. You may increase the age of the retirement of the judges, but don't do that. And judges are creating their own portfolios, their own appointments thereafter, with something that you have an education commission, and then you have a judge will sit there, and that is what the thing is that. But now again, we saw a Chief Justice taking up nominated member of Parliament. He being a public figure now we don't criticize him as Chief Justice. We do have right to speak about him, because now he's a political figure today. So how far it is justified? And that's all the public perception would change. So, yeah.
So your point is this. Mr. Arun Jaitley is no more, therefore it may not be fair to make any comment on him, because he can't answer if I make a statement. The point is, yes, it's a part of the parliamentary record. He made that statement those days. But then as a member of the government later, last few years, he was a party to all these appointments. That's how the politicians talk and behave, irrespective of the party. I have nothing to do with it. And then, in all fairness, it must be said, it didn't happen only in this government. It always happened.
All governments.
Always it happened. So the nature of politics is such. Appointments and this kind of carrots are always dangled earlier also. It is not happening for the first time now. Question is, in fact, I remember on one occasion when I raised an objection about the non-consideration of one of the present sitting judges in the Supreme Court. His name was not being, I don't want to mention the names. Anyway, it's all matter of the public domain. It appeared in the newspapers raised an issue. Of course, as usual, there are a lot of newspapers. Somebody supported me, somebody abused me, lots of things happened, all those things. And somebody said, no, government is playing with the appointments and this. No, but then what was Mr. Jaitley's answer? He's in public domain. He said it. He tweeted. He said, my friends in the Congress should look into the mirror. What did you do in the case of so-and-so? How did so-and-so come to the Supreme Court? So-and-so judge in so-and-so year. He is close to so-and-so member of your party. Somebody was close to V.V. Giri. Somebody was close to XYZ. It's all in public domain. You can check it. The question is, they are not just any politician who justify anything on a principle. You did it, so therefore why I should not do it is the only way they meet this problem. What about what you did? See, therefore, let's not go there. That's the game of politics. We can't help it. That's how it happens. Unfortunately, that is all over the world it happens. But in varying degrees of refinement will be there. But see, whether a post-retirement appointment is necessarily, see, look here, I made an announcement before I retired that I will not accept any employment under any government, irrespective of the state, union, party, irrespective of it, I will not accept any employment.
Excuse me, sir. So can you hold the microphone?
Sorry. Okay. I made an announcement, I will not accept any employment under any government. It's my personal decision. There's nothing to do with it. I'm not saying that somebody accepting an employment after the retirement necessarily compromised on his integrity while he was in office. We have seen exemplary cases, people like Justice Venkatachalaya and Justice Verma, who accepted post-retirement assignments like Human Rights Commission. But I don't think anybody in this country is willing to accuse them of compromising on their integrity while in the office, while sitting on the Supreme Court. It all depends on individuals. But a post-retirement sinecure has the potential of tempting human beings. After all, we are all human beings. And there's some temptation would be there. Well, if it is the consensus of the Indian society that it should be eliminated, just as Mr. Jaitley was articulating, well, it should be done. No difficulty. But I must also say, but for some of the posts, not for governorships and so on and so forth, but at least some of the posts, the experience gained by an individual for long years as a member of the judiciary might be useful. And more particularly in a country where people are made to retire at 62 or 65 and the life expectancy is much larger. Perhaps in a given case, the talent would go waste. It could be you, but then it all depends on whom you choose and what kind of a person is this. Maybe as a working arrangement, a cooling off period perhaps can be.
Yeah.
Might to some extent.
So could it be suggested that after retirement, at least for 5 years, no appointment? Because that's what maybe I'm saying. A government change in 5 years, and then people are more sure about it.
A government doesn't change, then what happens?
No, but at least we are sure about that. People have a right to.
It's a decision to be taken after a debate by all the concerned stakeholders. That's one possible way of looking at it.
Yes. Sir, let us take the issue of collegium. And we are not talking about how collegium and things came up with. And once we have decided the constitutionality, let us not go into this debate. The debate is something else. Debate is about the diversity index of our constitutional courts. Some reports, what we have, it says that women constitute only 7% of the judges' strength of the 25 high courts. Same with scheduled caste, scheduled tribes, which don't have an adequate representation. George Godboys Jr. in his book Supreme Court of India, he did mention about the percentage of caste and people getting elevated, and also those interesting stories about how people of our same category and same caste and same bar have been elevated. So we would like your opinion about diversity in the constitutional court, and how do you look at this issue?
See, these are facts. Of course, facts, there can't be any dispute about it. Whatever is published by Godboy or whoever it is. But question is something larger. My personal belief is, while in a democratic society, people from different segments of the society, let the segment be based on a caste, religion, region, language, whatever it is, are entitled to be represented in public institutions. But when you simply make it a rule, you are, at least in the context of the judiciary, you are compromising on something more fundamental. Unfortunately, what I'm not saying that those who are appointed are always wonderful. I'm not on that. I'm not at all on that. That's my complaint exactly against the collegium. See, when you are choosing somebody to the court or rejecting somebody to the court, I would expect the first consideration should be what is the quality of the judgments written by this particular judge in the High Court when you are bringing him to the Supreme Court or rejecting. Or when you are considering somebody for elevation from the bar or from the subordinate judiciary to the High Court, what is the quality of the argument of this particular lawyer, or what is the quality of the judgment of a particular district judge who is under zone of consideration should be the primary consideration. Okay. And I haven't seen any such consideration going in any one of these deliberations. Well, at least I can speak to the period where I was there. And a few of my peers who were members of the collegium, all Jumapal went on record. Well, this is something which hardly takes place. The only thing is, all India seniority, where is he there, and whether this particular High Court is represented in the Supreme Court or not, or whether this particular community, well, there may be relevant considerations, but then they can't be the only consideration. That's all I'm saying. They are relevant considerations. Look here, as I told, and the lighter beam, there is a joke in the American legal world. I don't readily recollect the name. I think most probably it was Eisenhower or Truman. I don't remember now readily. I can check up and tell you, or you can check up. So after he laid down the office in one of the press conferences, somebody asked the former president, see, look here, you nominated X and Y, 2 judges to the Supreme Court, who are by any standard mediocre. How did you choose them? Then that man with a very stern face, the president answered, look here, in a democratic polity, every segment of society is entitled for a representation in public bodies. So are the mediocres, he said. Okay, that's on the lighter vein of it, but it happened. Right. It actually happened. Okay, the point is this. That should not be the primary consideration. How many? No, I have no... In fact, I'll tell you something. When you talk about gender, you forget about the Supreme Court and High Court's percentages. You look at the subordinate judicials of the district judges and junior civil judges recruitment. At least my experience with 3 High Courts, I was associated with 3 High Courts. The erstwhile Andhra Pradesh, which is divided into 2, now it becomes 4 High Courts. Telangana and Andhra Pradesh, Kerala and original Guwahati High Court, which is split into 4 High Courts now. It was 1 High Court when I was the Chief Justice of the 7th stage. Now it's 4 High Court. Women do exceedingly well in these selection processes. You check up the history for the last 10-15 years of these High Courts and the recruitment figures. It is more often the ladies who walked away with the lion's share in the recruitment at the subordinate judicial level. And I always said it in the last few years in my own friend circle. In the next one generation, this profession is going to be dominated. The judiciary is going to be, profession may be dominated, may not be, but the judiciary is going to be dominated by women. It's already happening in the subordinate district judges level. Now, High Courts and Supreme Court, just because you gave out the figures and I can't quarrel with facts. It's happened. Why it's happening? Please remember, what we consider to be a great democracy, America, had a first woman judge much after India chose the first woman judge to the Supreme Court. I'm sure you must be knowing it, Professor, if not all the participants. So, I'm not saying that is therefore that all problems are not solved. I'm not saying it. See, actually, I'm always very fond of, I quoted this more than once. Lawrence Tribe, in his on his commentary on the American Constitution, in the preface, he writes, "The Constitution is an intentionally incomplete and deliberately open textured document for the participatory evolution of democratic practices," he says. That's the essence of democracy. See, nothing happens overnight and everything will not be perfect overnight. But once you have a democratic system in place, for a period of time, with all this churning, things would improve. As Ambedkar was saying, and a predominantly feudal society imposed a fine Western model of democracy on a fine night, midnight at 12 o'clock. And you expect the whole thing to change the next morning. It's a long churning.
Yeah.
And what matters is the awareness of the civil society and their ability and willingness to tenaciously fight for the liberties and system and a constitutional governance. Fighting, when I say fighting, I don't mean physical fighting. To stand up and assert their rights and views. Quite often what happens is most of our views are confined to the drawing room. We don't speak in public fora. And another unfortunate point is, in this country, large number of so-called learned people, they have one opinion in the drawing room and another opinion on a public platform. So privately, they have something about some opinion. But on the same topic, when you ask them a question in public, of course, they give a diametrically opposite answer. This is the trouble with the democracy, the Indian democracy.
What we could gather is that we cannot suggest from what your presentation, that we cannot suggest a definite quota, because your performance as a judge, your judgments do matter a lot. That is the first parameter.
I'm talking about the principle.
Principles, yeah.
Talking about principle.
But
that should be the first consideration.
The first principle. But definitely diversity should be considered.
Should be there.
Because anyway, now you speak about that, which high courts are not represented, which communities are not represented. Only point is that when it comes to women judges and when it comes to Dalit and Adivasis, the discussion has a less priority to get into that, how they are not represented into a higher judiciary. And we have a report in the parliament which speaks that there should be reservation in judiciary. So,
if the lawmakers believe that is the answer to it, let them make it.
That's a report. But it has also been argued, sir, that diversity basically enhances the court's legitimacy. It builds public confidence in the court, and it always feels that past inequalities have been remedied. It is also a way symbolic, in a sense, that people from a non-traditional background could also bring a very different viewpoint, because justice is not also about 1 + 1 2. It is also the worldview what we have. And so while selecting people to the court, to the bench, is it something that the worldview of a person been considered? The philosophical understanding of a person been considered? Because we have people
not to my knowledge, so long as when I was in the college, none of this kind ever happened. I don't know what is happening now, what happened before I entered. I can only speak for the period when I was there.
So the philosophical viewpoint is never a matter of consideration of a person.
I can only speak to that period when I was there.
Yes. So the last question from my side, and then we'll take questions from the audience. So the collegium system started with the judges transfer case, the SP Gupta case. The High Court judges were transferred.
No. It started in 93. Before 93, SP Gupta's case, collegium was
no, collegium doesn't start, but the judges transfer case did come up with appointment of judges issue started with for more discussion. And then collegium comes with the next part of it. Sir, right now, again, we are looking at transfers of High Court judges has been increasingly used many a time as a way of rewarding and punishing people. Would you like to throw a light on this allegation which has been made? Akil Qureshi's transfer, for that matter, from Gujarat High Court, or Murlidhar, when he takes the matter and immediately he gets a warrant to be transferred. It was very much in the pipeline. This is some judges been shown to go to Meghalaya from a very heavy court like Chennai, where you have a chartered court, and then you again send them to a court where you have very less litigations coming up. So is it something been looked into from the service point of view as rewarding and
See, well, in both the cases you mentioned, I was not there. I retired.
Yes, sir.
I don't
Yes.
know what transpired there. But I see, all this is not, my views are irrelevant. What I stopped attending the collegial meetings. And why did I stop? I made it a public announcement. It's almost in public domain, though I didn't make an announcement. It all came out in public. I said, please record your reasons. Nobody knows why something is happening here. No, I'm not saying the entire, you publish the whole process, you know, like the parliamentary proceedings, you broadcast it to the nation or something. That was not what I was pleading for. So let us say if the collegium is deciding to transfer X judge from X, some A court to B court, why is the transfer? Now, on this transfer, of the members of the collegium, 1, 2, 3 may agree for the transfer. 1, 2 two others may not agree. The various combinations are possible, 4, 1, 3, 2, whatever possible combination. But if you don't record it, simply voting yes or no, we don't, the other members, suppose I don't agree with you, but I don't know why you are saying yes, nor do you know why I'm saying no. So this is no discussion at all. Then what is the point in having a meeting? That's why I said I will not attend it. What is the point here? Simply having a cup of chai and then saying yes or no. I might as well say it in writing. You take a decision, you communicate it to me. That's all I said. Because it's not only the other members are required to know. Consultation means applying, you sharing the material and coming to a logical and rational and conclusion which is in the interest of the institution and nation. Not somebody proposing and 2 more people agreeing with that somebody. So it makes majority 3, therefore yes. This is not voting.
Does it mean that there's no meaningful consultation which actually happens?
That's what I wrote. That's what I protested. I said, I'm not sorry. There's no point in attending this kind of a meeting, I said.
So transfer of judges is the most guarded secret of the Supreme Court.
Yes, nothing is recorded. Please ask the Supreme Court to give us the reasons of the transfer of any one of these people. Forget about this more controversial and publicized thing. There are a lot of transfers. Akhil Qureshi or the other Murli. Forget about, okay, there are high profile cases for good, bad reasons. That's all. Forget about, don't trouble them. There are already people troubled. There are many more people whose names are not discussed in public. At least let us know the reasons why they were transferred.
Right.
I'll tell you something. See, it all depends on when I was the Chief Justice of Kerala, the then Chief Justice of India, Justice Kapadia, wrote a letter to the Chief Justice Kerala. I happened to be the incumbent, proposing the transfer of X judge from a particular High Court to Kerala High Court. And it's a simple 2-9, not only in that case, in every case it's a 2-9 letter that comes, saying that, dear Chief, dear brother, so-and-so, it is proposed to transfer X judge from a High Court to your High Court in the interest of the better administration of justice. This is the phrase you also use, better administration of justice. I would like to elicit your views on this proposal at an earlier date. Because this is a requirement of that 93 judgment. Even transferring, you must seek the opinions of not only the collegium, both the High Courts, transferor High Court and transfer High Court, they are required to be consulted. So in compliance with the so-called requirement of the law, this letter is written. Well, of course, I had always been a little insolent fellow. Well, it's a different matter. I wrote back to Chief Justice Kapadia. I told Chief, I neither know the man whom you are proposing to transfer, nor the reason for which he is being transferred. What is the opinion I can give about it? Since you have decided to transfer, please go ahead with it. I have no input to give in, because I don't know the man. I never met him. I don't know the reason why you are transferring him. What is the view I can give you?
Right. So this comes to one question, that to whom the judiciary is accountable to: the parliament, the president, the people, or to itself?
to all. First of all, conscience of individual judges. The ultimate.
Sorry. Yes.
First of all, to the conscience of individual judges, they are answerable. Secondly, in the constitutional system, they are indirectly answerable to the parliament, in the sense parliament has the authority to impeach them in a given case, an appropriate case. So therefore, in that sense, they are answerable to the parliament, not for every decision they render, but that answerability is there in principle. Third, ultimately, either the parliament or the judiciary, they exist for the people of this country. When you talk about the constitution and the preamble, we the people of this country, we have given this. It's the people who gave us all this power, all this, that wonderful building and Luton Delhi bungalow and a car with a hooter. Of course, now they are not there for the last few years. All these things are given by the people of this country. We are paid out of the tax paid by them. So eventually, in the larger context, we are answerable to the people of this country.
So the people of the country would...
Point is, elected people periodically go for an audit. We are not answerable because we hold secure tenures. So therefore, our responsibility is more profound. Therefore, we need to be more guarded in what we do, what we say, what we decide.
Thank you so much, and therefore this is what the people of Kashmir would want to know, that when a habeas corpus petition will be heard and what urgency. Yes, sir, this is what we're talking with the audience right now. And what would be the how, when you feel that there's an urgency of right to life and liberty to be decided. Dr. Ambedkar said Article 32 is the most cherished article. It's a life and blood of the Constitution. When we can't invoke it in time, what is the meaning of this whole thing for the people of Kashmir who have been detained for a year? There are a few questions which are from the audience. Vaidehi, would you like to take the questions from the audience?
Yes, sir. Shall I begin? Yeah.
Yes.
Yeah,
Over to you, Vaidehi.
Thanks a lot, sir. So first, one of the participants would like to know from you, sir, that what is your opinion on National Court of Appeal that is being established at least in 4 cities, Bombay, Calcutta, Chennai and Delhi, which
being
can
established.
Work,
Is there a proposal to establish?
No.
There's some vague idea floating.
These are vague ideas. We still have an appellate court and the Constitutional Court, the same court.
Well, you want my opinion on that?
Yeah. So comment on this part. Yeah.
I am totally against it. It doesn't serve any purpose. Totally against not because any personal this thing. What is the purpose it's going to achieve? See, for 100 years before 1950, when the Supreme Court came into existence, this country functioned only with High Court. Of course, there used to be appeals to the Privy Council in a limited number of cases, and later for a short period before the Federal Court. The High Courts were the last courts, and they enjoyed greater prestige, greater reputation, greater authority, and greater intellectual strength. And then today we have a Supreme Court. Why do you want to create one more court in between? Since we have not structured our system, now these demands. Okay, what happens if the Court of Appeals is created under 136? Anyway, any judgment of any tribunal, including a municipal junior civil judge, is amenable to the 136 jurisdiction. And these big lawyers in the Supreme Court next morning file a SLP saying is one more tier of scrutiny, only delaying the process. Nothing more will happen. That's my belief. Therefore, I am totally against it. But I don't think it's against in the sense, I don't think it will serve any useful purpose.
Yeah.
And who are going to be the judges of this court? Same High Court judges will be taken there. What happens? What transformation comes? If they're good enough there in the High Court, or if they're bad enough in the High Court, therefore there is an appellate court, then they'll be bad enough in this court also. Without meaning any personal offense. Yes. I'm only on the logic part of it.
Yeah, with the next question.
Next question is, why are people's rights, including that of freedom of expression, are always coupled with duties as if they will not have these rights if they don't or can't perform so-called duties. So that's another question. And
See, any right in theory, in jurisprudence, every right comes with a corresponding obligation. There are no rights which are absolute, unfettered rights in jurisprudence. See, if I have a freedom of speech means, sorry, don't mistake me, I need to drive home the logic I'm making. Can I abuse you? Can I give galis to you? Okay, please answer me my question. Can I give galis to you? Please answer my question.
no, not at
Why? I have a freedom of speech. Why can't I abuse you? Tell me. I want to know the logic.
that is like insulting somebody else's. Yeah.
No, so yes, but that's my freedom of speech. Why don't I accept it? Because you have a corresponding right. You also have a right of dignity that is required to be protected. So that
it's actually transgressing somebody else's.
Sorry.
Yeah.
So
this
to preserve.
This is like abusing somebody is something like transgression of somebody else's or making an aggression.
Precisely. So that becomes the limitation on my right.
Yeah.
So that becomes the limitation on my right to free speech. So therefore,
limitation is okay. Why duties? Why duties?
But where does the logical foundation for that limitation is this? When two rights come in conflict, my right and her right to live with dignity and my right to free speech come in conflict, necessarily my right of free speech is required to have a limitation on that.
Yeah. So we have a reasonable restrictions
it's
on our
only,
liberties.
Yes, we have everything.
Yeah. And they cannot be an absolute liberty at any point of time.
That's right. It can't. In a society, there's nothing absolute.
The only point is that the limitations should be reasonable and should not be excessive. That is what and where the role of judiciary do come in.
That's right. That's where the Constitution comes in.
The Constitution.
That's where the judiciary comes in enforcing or interpreting the Constitution.
Whether we can take immediately few questions, Vaidhi, because I think there are this.
One more question. There is a strong view about the court's institutional failure.
Madam, I hope you are not offended when I chose the example. I only gave it as an example.
No. Not
just to drive home the logic. That's all, nothing more. Sorry, tell me.
So the question is, there is strong view about the court's institutional failure to do justice in the case involving sexual harassment allegations against a former Chief Justice. The way the issue was handled was against all the basic principles.
I think I may be excused from this question. There is some difficulty in this matter.
All right.
We'll
move to some other. You will need other questions.
Yes, some other question.
So maybe from chat box we can take a few more questions. Yeah, this is again about Kashmir. So sir has already covered about it.
Kashmir has been covered. Diversity has been covered. Then regarding police violence and torture of innocent criminals, why are judges and why judiciary silent? This is one of the question. Maybe this is relevant to some excessive police violence in recent time, which happened during some protest. And why judiciary is silent about it?
One second. Against police violence, the judiciary has. There are occasions here and there where the judiciary was silent, but by and large, in the last 70 years, the judiciary reacted to police violence.
More activist court we have in this case. In criminal jurisprudence, we have a very liberal and activist court. Habeas corpus petition, so that was again been taken, that the whole part. Kashmir habeas corpus petition is pending. Milind, I suppose that so said that he will not be commenting on it, and when he said itself that the judiciary is also accountable to the people, and therefore I think we could definitely ask them that how long would the court take to listen a habeas corpus issue, and then. It was something that during emergency there was one thing which is called as a committed judiciary.
Not even before emergency. It all started after
No, but that was Mrs. Indira Gandhi's time when this term was used, committed judiciary. And
even before emergency. Even before, that's all I'm saying.
Also, and a judge who punished him was also been referred to as a pity judge by the same people. So do you think that this whole part still continued of having a committed judiciary?
Come again? What is the question?
So do you think the same thing of what happened before emergency also, that the idea of having a committed judiciary is still prevalent? That there's an expectation that we should have a committed judiciary?
Every politician would love to have a committed judiciary. Names don't make any difference, party names or individual names. Anybody in power would love to have a committed judiciary, committed quote unquote.
So, no government is an exception, and
at least that's my belief. My own experience shows it.
So, what is the scenario? Because committed judiciary we saw in a habeas corpus case, that has been academically criticized and dissent has been upheld, and it is on record how the Bar Association of Supreme Court itself has passed a resolution regarding it. So,
about what?
About the two judges who changed the side in the habeas corpus.
When did they pass the resolution?
So this is on record, which means this has been noted down by Kuldeep Nair in his book The Scoop.
That's right. But when was it passed?
So it was post-emergency. It was post-emergency, not during emergency.
That's right.
So the point is, what is the scenario today? Same scenario.
See, what did the Indian Bar do? Forget about all the Prashant Bhushan. I'm not worried about. Forget it. My views are on public domain already. When the Attorney General was not permitted to say what he wanted to say in the court, what was the Indian Bar doing?
True.
Well, there's some 5 years later, somebody passed a resolution saying that the court ought not to have done that. But then suffer all these things till then. See, I mentioned earlier also, somebody asked this question on some occasion. Liberties do not belong to the timid. Liberties do not belong to the timid. Only the bold will retain their liberties.
Great. Yeah. Whether we have...
can we take one or two more questions?
One or two questions and then we'll conclude. It's 1.5 hours now, right? Yeah.
So the question is, what is the future of highest judicial court of India? Do citizens have any role in ensuring that the judiciary performs its constitutional obligations and duties?
Madam, I don't know astrology. I can't predict the future of anybody, including the institution. I don't know. But I can say this. Citizens only have a role in the success of a democracy, not only judiciary. In fact, there is a famous quote, though I'm not very fond of quoting, but certain words become so profound and immortal. There is no option but to quote them. You can't substitute your language there. Late Mr. Palkhiwala very frequently quoted it. There was a famous American judge called Joseph Story. Story wrote a commentary on the American Constitution. And he said, talking about the American Constitution, in the full quote, I don't remember, you can check up it. In fact, if you recollect, people recollect, Professor Palkhiwala wrote that book, Our Constitution, Defaced and Defiled. Do you remember that book?
Yes.
Huh? In the second cover of the book, he opens with this quote of Joseph Story. Just check up that full quote. In substance, what he says, talking about the American Constitution, Story said, the structure is beautiful, the American constitutional structure. Its defenses are impregnable from without. Now, full text I don't remember now, long back I read it. Nonetheless, it may perish within an hour of the folly of its only keepers, the people. It's the people. Without the people's awareness and their consciousness of their liberties, No democracy survives. Forget about the Supreme Court, Parliament, or anything. The democracy itself will not survive. It is the eternal resilience of the people, the civil society, which keeps the democracy. That's the price which you pay for democracy.
Yes, yes.
You don't daydream. Look here, I hold a webinar, or I think everything should be fine. Supreme Court judges should be fantastic. Parliament should be fantastic. That's not going to help. If things are not going right, you have basically an obligation to point out things are not going right. It's a part of the democratic process.
Yes.
And if you're timid and you don't want to stand up, and outward, don't complain against anybody and say the democracy has failed in this country or that country or this institution. They're bound to fail.
Yes.
Now, in the process, if you stand up, you may have to face a lot of discomforture. When I held the press conference, though I'm not very fond of speaking about the conference, in fact, my opening statement is with no pleasure we make this press conference today. But I was not a child. I was not unaware of the fact I will have to face bitter criticism. That's the price I paid for it. I was willing to pay. I believe. I may be right or wrong. History will record. History will decide a generation later whether I was right or those who criticize me are right. It will be decided later. But I was not a child not to understand what is going to hit me. I understood perfectly.
Yes. Yeah.
Yes.
Vaidhi?
Take one more. Yeah. Shall we take one more question?
Oh yeah, I have no problem.
We'll take one more and we'll conclude then, right?
Yeah. Would decentralization of judicial power aid democratization of the judiciary? That is to say, would removal of hierarchical structure and one apex court and the establishment of several courts with equal authority at the same level aid with things like a backlog of cases and the ease of outside influence on the court, political or corporate?
See,
so that's the question.
7 courts or 8 courts in theory. By the way, are you a lawyer? Are you a law graduate?
No, sir,
No.
Okay.
I'm asking.
Okay. I just want to know as a matter of fact. See, high courts are as constitutional courts as the Supreme Court is. The only difference between the High Court and Supreme Court is that the jurisdiction of the High Court is limited to a geographical area, whereas the Supreme Court jurisdiction extends to the entire territory of India. Within the territory of the area over which the High Court exercises its jurisdiction, qualitatively there is no difference between the High Court and Supreme Court, in theory. Now, therefore, question is, it's not by creating 7 or equal. No, so long as these principles, like you look here, the master of the roster principle is one thing. Second thing is this power to transfer judges, the collegium. These are the things which ultimately create the problem. When I entered the profession, the High Court, Chief Justices of a High Court never thought of going to the airport to receive the Chief Justice of India. I'll tell you something. I don't know. I was not a witness, but my elders in the profession told me in the High Court, when Andhra Pradesh, old Andhra Pradesh, not the present Andhra Pradesh, the undivided state of Andhra Pradesh as it existed prior to 2014, that came into existence in 1956 after the state's reorganization. The High Court at Hyderabad came into existence. Andhra Pradesh, the court existed as a High Court of Hyderabad, but then it became the Andhra Pradesh High Court after 1955. Justice Subbarao, who later became the Chief Justice of India in 1967, was the first Chief Justice of Andhra Pradesh High Court. It appears one of those days, the President of India, Babu Rajendra Prasad, was the President those days. He was in Hyderabad for every president has an annual sojourn in Hyderabad. It's some convention. When he was in Hyderabad, he wanted to visit the new High Court. Formal communications were exchanged between the Rashtrapati Bhavan and the High Court. Rajendra Prasad came to the High Court. To the eternal glory, the seniors of the profession, my seniors, because I came in 1976 when this event happened, I was 2 or 3 year old. Seniors used to tell us, when the president came, Chief Justice Subbarao did not go down to the corridor, the portico to receive the president. He asked the Registrar General to go. No, the Registrar General's post was not there. It was only one registrar those days. He asked the Registrar to go and receive the President of India. Waited outside the Chief Justice Chamber's door, threshold, to receive the President. If any Chief Justice tries this stunt today, next morning he'll end up in Sikkim. I know it. I know it. And somebody going to the airport to receive the Chief Justice. Now today, if a member of the Collegium is going to a state headquarters, quite a good number of Chief Justices are... I don't blame them. We have created such a system because your survival, your prospects depend upon the pleasure of the members of the Collegium. Therefore, they think that it is wiser to be present in the airport. So therefore, creating 7 courts or 6 courts doesn't make any difference.
So we need people who can stand erect.
It is the mission. It's the mission character. It's the character of the
bend.
nation.
Character of individual matters
If
a lot.
you think the office is bigger than you, finished, over. If
Yes.
you think you are bigger than the office, everything is safe.
Fine. Whether that requires that we can have 2 more questions because there are many questions.
You can take any time. You can. This evening I kept myself free. You can take any time.
Whether we can take
Subject.
2 more questions because there are a lot of requests which I have receiving.
All right.
Please.
Shall I ask for the question? So,
Yes, please.
The question is, why is sexual harassment of a woman at workplace, that is Prevention, Prohibition and Readdressal Act 2013, not applicable to Supreme Court and High Court judges? So that's the question.
Why don't you ask this question to the... I am a retired judge. Why are you asking me this question?
I think that question in other context, he said he didn't refuse to respond. When you spoke about Justice Gogai's incidents, he said he didn't want to respond. So we can go to another question then. Now.
So so there is a one more question that okay, again on the similar lines the questions are. So I think
okay. Right. So do you want to give any concluding remarks now? No.
I have spoken. enough.
You've spoken up your mind today. Thank you so much, sir, for candidly putting up the issues very clearly. I think no former Supreme Court judge has so candidly put up the issues. Right, saying that transfer of judges would.
There are some more people. Fortunately, there are some more people who have put it already.
But there are very few who were sitting on there and who came out and said that we owe to our nation also, and we want to answer. What is the best part is that you have very categorically said that we also are responsible according to the people of India, and people should be vigilant. Not only about the parliamentarians and executives, but also about the judiciary. I think this effort of Pune Collective is whole part that people should speak up about the wing of a state which has not much been discussed and always thought about that they are above the law.
Can I make one comment? It's not a concluding comment in the context of what you said.
Yes, sir, please.
Don't take it. I'm saying it in a light way, not in a derogatory.
Yes.
See, if the whole nation, a good number of the people are willing to, beat plate because of that COVID. You remember sometime back, light a candle. So why don't you do it when you think something is going wrong? Please stand up and light a candle and hold it out in the balcony. Do it. That's the least you can do it.
Unfortunately, people thought they're celebrating COVID. That was the worst part of the whole. but
is our understanding? Then let us suffer it.
Yeah, that we are suffering for. But that is the whole part. Why don't we come out and speak out?
Just one second.
Yes, sir.
When the Prime Minister asked the people to do it, light a candle, this tokenism has a great significance in the history of any society.
Yes, sir.
So it is building up the morale of the people. Look here, we are fighting here. So see, it's a serious thing. When the Prime Minister asked the people to do it, he understood the implications of it. That collectively people must feel that we are willing to fight it. That is the symbol. That is the thing which he's right. In a situation like this, people need to fight the situation. How to fight? There are a lot of questions out there. I'm not saying that there the whole thing ends. It's only a token gesture. But at least make that token gesture when you think something is going wrong. If you don't even do that, then after don't say, look here, this is not right, that is not right, that institution is not functioning, you are not doing right things. Well, there's no point in lamenting all this. That's all.
Yes. So that is what, when something goes wrong, you should speak out. And liberty belongs to those who are not timid.
They don't belong to timid, at least.
Yeah, they doesn't belong to timid. It belongs to people who can voice their concerns. And I suppose that is what the takeaway from today's webinar would be, that we spoke about many issues. We spoke about diversity in judiciary. We spoke about collegium system. We spoke about transfers. We spoke about how the priorities comes in while deciding the matter. And his lordship was kind enough to candidly put up his opinions. And this would definitely go a long way for all of us to rethink over that if you want this democracy to be meaningful, then it's not only about regular elections. It's not only about elections, but we should also question the form of democracy what we have. And nobody is above a fair criticism. So long we keep on questioning them, I think people in position, people in power would be made accountable to us. I thank Pune Collective for inviting us for this important topic for deliberation. Now it's over to you, Vedehi, for your formal vote of thanks.
Thank you, sir. I thank both the speakers for such a insightful session, very informative and eye opener, mind opener both ways. So at the end, I would like to say that भारताचे संविधान हे एक तत्व आहे ज्याच्या आधारे भारतीय प्रजासत्ताक तिच्या संस्थेची रचना आणि कार्यपद्धतीची आखणी करते आणि नागरिकांचे मूलभूत अधिकार, निर्देशांची तत्वे आणि कर्तव्य देखील ठरवते. आपल्या आजच्या वक्त्यांच्या मांडणीतून या तत्वाची, तिच्या रक्षणाची, त्याचवेळी नागरिकांनी त्यांचे मूलभूत कर्तव्य पार पाडण्याची गरज अशी जी आहे ती अधोरेखित केलेली आहे. आणि आम्हाला आशा आहे की आपण सगळेच आपली ही भूमिका नक्कीच निभावू. We believe it is not just the murderers of Narendra Dabholkar, Govind Pansare, M.M. Kalburgi and Gauri Lankesh are aimed at instilling fear in those who dissent or ask questions. It is every lynching, every atrocity, every attack or on students or on an activist, and every arrest of persons conveniently labeled as urban Nakshal that is part of this larger hateful vendetta. Before coming to the end of this session, we would like to remember and salute all those who dissent, ask questions, and are willing to hold people in power accountable by holding our constitutional values to save our democracy. आज 5 सितंबर गौरी लंकेश की शहादत की तीसरी वर्षगांठ. ये सवाल उठाने का काम गौरी लंकेश ने किया, इसीलिए उनकी आवाज खामोश करने की भी कोशिश की गई. पर आज सारे देश के साथ हम भी गौरी लंकेश की आवाज बन के खड़े हैं और इसी विचार को हम क्रांतिकारी कवि फैज के अल्फाजों में बयां करना चाहते हैं. बोल कि लब आजाद है तेरे, बोल कि लब आजाद है तेरे, बोल ये थोड़ा वक्त बहुत है, जिस्मो ज़बा की मौत से पहले बोल कि सच जिंदा है अब तक, बोल जो कुछ कहना है कह ले, बोल कि लब आजाद है तेरे. I would like to thank all for joining us, especially both our esteemed guests and speakers. It was indeed a very important session we had tonight, and because of your valuable inputs, now we have a perspective. Thank you once again.
So
I would like to
Thank you.
thank you
Yeah.
all.
I would like to thank our wonderful audience. Because of you, this session became more interactive and engaging. Last but not least, I would like to thank all our friends, supporters, and our entire Pune Collective team who made this possible. Thanks all. And before you go, just one quick announcement. We will be having our next live session on 19 September 2020. आमचे याआधीचे सर्व सेशन्स YouTube आणि Facebook वर उपलब्ध आहेत. For that, you can search Pune Collective to know further. Keep in touch through our social media handles We are on Facebook, Twitter, Instagram, and YouTube by the name Pune Collective. Thanks a lot, everyone. We'll see you again soon. Thank you.
Thank you, Vaidehi. Thank you so much. Thank you, Lordship.
Right, sir.
Yeah.
Thank you.